Hello, I am Laura Danielson. Welcome to our podcast on immigration law under the new Trump administration. Honestly, we're all kind of holding our breath, wondering what is coming down the immigration path once Donald Trump takes office. There is a palpable fear out there among many of our clients, and people are a bit on edge. Part of this is due to the president-elect's campaign promises, in which he said that he will begin deportations on day one. Another is due to his 10-point plan listed on his website. Here are some of the key items as they impact our clients. In the beginning, the promise was to deport all 11 million estimated undocumented immigrants. But as reality has set in, the focus is really more on those who've committed crimes. And Donald Trump has said he's estimated that to be around 2 million deportations that he wants to see. He has also promised to repeal DACA, which is the Deferred Action for Childhood Arrivals, which has given temporary status to an estimated 650,000 young people, and which I'll talk about more in a moment. He has also talked about an overhaul of employment-based immigration in favor of U.S. workers and eliminating and renegotiating NAFTA, which Bob will talk about next. Increased enforcement is definitely on the agenda as well. While this relates to border security and the idea of building a wall, it also relates to employment and compliance, which Lon will be discussing. We've heard quite a bit about extreme vetting of certain groups, whether they be refugees or people entering on visas. Debra is going to go into more detail on these potential policy changes and the impact on employees. But before we go into the details, let's back up a step and consider how much a president can actually do. Immigration law is administrative, which means that it falls under the executive branch of our government to enforce our immigration laws. Congress, however, still makes those laws, and most major changes cannot occur without new laws being passed. And remember that even though Congress is now controlled in both houses by Republicans, the party is far from lined up to act quickly or cohesively. There really are still many differing points of view, and there's a great deal of dissent about immigration policy that's on both sides of the aisle. Furthermore, Congress must vote to fund various initiatives, such as increased enforcement. Remember that most immigrants still have a right to a hearing before an immigration judge before they're going to be deported. And increasing deportations will surely require additional funding for both enforcement personnel and for judges. Now, immigration regulations are drafted by the administrative agencies under the executive branch, like USCIS, to implement those laws that Congress passes, but they are subject to various rulemaking procedures. The tone is set by those in charge as to the adjudications and implementation, and to that end it really does matter who is being proposed to run the ship. John Kelly has been chosen to run the Department of Homeland Security, and Jeff Sessions to be our Attorney General, and both obviously have been chosen to implement a very strict immigration agenda. So stay tuned to see what happens with both of them. I'm not going to go into details right now, but keep your eye on that. Stay tuned. But still, government regulations cannot be what we call ultra vires, or outside of the actual legal framework enacted by Congress. If they are, that's what our courts are for. And historically, our courts have given a great deal of deference to Congress and its plenary powers to legislate in the area of immigration. So there is not a carte blanche for the executive branch to just move ahead and enact really strict immigration regulations. Finally, the executive, which which really means the president, has no inherent powers over immigration laws. So there really is a limit as to what he would be able to do without congressional support. So, what might President-elect Donald Trump actually be able to do immediately or within, let's say, the first 100 days? First of all, he could rescind DACA, which was an executive action by Obama. Basically, an executive action is a directive to a federal agency by the president to do certain things that are still within the legislative framework. Trump has the authority to rescind any of Obama's executive actions, including DACA. But will he really? It's estimated that nearly 90% of all DACA recipients are currently working, and that terminating the program could lead to hundreds of billions of dollars of lost gross domestic product over the next 10 years. DACA, in my opinion, DACA is likely to be rescinded, but Donald Trump has recently softened his tune, and some are suggesting that Congress may actually pass a form of DREAM Act that will protect the DACA recipients. And we don't really know what this would look like, but it's interesting that it's even being discussed. And so stay tuned for that, because that is something that could actually happen very soon with the new Congress. Secondly, Donald Trump could also redirect enforcement and deportation initiatives under our current agencies. And Lon is going to discuss that in much further detail. Fourth, the president has broad unilateral discretion to determine refugee policies and the number that we take in each year. So keep your eye on what happens there. For example, with Syrian refugees or others from the Middle East. We've heard a lot of discussion about that, and I wouldn't be surprised if we see a real reduction in refugees, particularly from Muslim countries. And finally, as far as my part of this discussion, the president also has the power to bar access to the United States for specific immigrants or groups, particularly if he believes they pose a threat. It is not as likely that this will involve a blanket ban on Muslims, for example, per se, because that would be considered discriminatory, and there would be a whole host of court actions that would likely follow. But there could be a real bar on specific groups, and at the very least a tightening of border restrictions. And Debra is going to discuss with us how we expect this to play out. So, okay, Bob, please tell us some more about expected revisions to employment and regulatory changes.
Hi, I am Bob Aronson. I'd like to take a few minutes to talk about some of the issues and some of the expectations coming out of the new administration in the realm of employment-based immigration. We have a lot of uncertainty as to the directions that President-elect Trump will choose to undertake. On the one hand, he is a product of the business community, which in general has supported employment-based immigration. And as such, that should create a very strong influence on his policy proposals. On the other hand, one of his major constituencies has been blue-collar workers and in general a commitment to restoring jobs. And he has also painted immigration as a massive job giveaway program, in particular the H-1B temporary worker provisions. So there's a certain cacophony of influences in his developing policy proposals. And what I'd like to do over the next 10 minutes or so is to try to parse out not so much the bottom line of what's going to happen, but some of the considerations that we'll be looking at over this forthcoming period of time. I want to, in particular, focus on 6 visa types which merit some type of consideration in the realm of employment-based immigration. First of all, and most importantly, I want to talk about the issue areas that may be undergoing revision in the H-1B temporary worker program. And that's the most controversial. Secondly, let's talk a little bit about the PERM labor certification application, both in terms of qualifying foreign nationals for permanent residence under PERM applications. And then it's also a good introduction to the comments of Lon Wynn in terms of the compliance aspect, which we can expect in the permanent resident arena. Third, I'd like to speak about F1 students, the feeder source for high-quality knowledge workers in the United States, and in particular, possible vulnerabilities in the optional practical training, and in particular the STEM OPT, or STEM optional practical training programs. And I want to explain why it is so critical that these programs be left intact. Fourth, we've heard quite a bit of commentary on possible revisions to the NAFTA Accords. Part of the NAFTA Accords provide immigration status to professionals from Canada and from Mexico, and therefore a revision in NAFTA could have some serious spillover effects in the immigration arena. Fifth, I want to say a few words on the EB5 Investor program, and sixth, just a few general comments on the whole panoply of other employment-based immigration categories. So let's start with the H-1B temporary worker provisions. By definition, the H-1B temporary worker provisions constitutes a temporary non-immigrant visa category that covers a broad range of professionals working in the United States. It initially requires clearance from the Department of Labor to ensure that the employment will take place under non-discriminatory wage and working conditions, and then the focus shifts to the immigration authorities, to U.S. Citizenship and Immigration Services, to determine whether the position is a specialty occupation, that is a professional position. In the campaign, President-elect Trump designated or labeled the H-1B program as a job giveaway program. And there have been certain uncertainties and certain vulnerabilities, particularly in the IT field and in particular in the job shop situation. So this is a visa category that has been attracting a great deal of attention over this past period of time. While we don't know what will transpire, we do know that there are some movements to tighten up the H-1B temporary worker provisions, primarily on focusing on the wage issue. So there could be revisions which do anything from requiring employers to go through some type of labor market test, like a recruitment program, to ensuring that the wages being offered to an H-1B beneficiary meet certain guidelines, either in terms of being at the upper echelon, called level 4 or level 3, wage levels as set by the U.S. Department of Labor, or being a certain percentage above the norm of similarly qualified U.S. workers. So the manipulation of the wage issue in and of itself could be a significant tightening up and a significant detriment to H-1B utilization. I think we may also see some movement or some initiatives in terms of carving out the IT job shop sector as having certain particular requirements that need to be fulfilled in order to get H-1B status to an IT contracting company. So these are all things that at some level or another will probably be entering the hopper over the next period of time. Picking up on one of the major points raised by Laura, revisions to the H-1B is not something that can be undertaken and consummated unilaterally by the President. It requires, in most instances, congressional action to revise the statute or regulatory revision undergoing new rulemaking to develop new regulations, because it's the regulations that control the entire pattern of what's required for H-1B coverage. Moving on to the PERM labor certification application. This has been something that has not really hit the radar screen during the campaign. There's been very little mention or review of revisions in the PERM labor certification application and process, which is the process under which an employer needs to recruit and advertise and go through a series of steps to show that it is infeasible or impossible to hire a fully qualified U.S. worker, and that the job is being offered to a foreign national under acceptable wage conditions. As a result, I think that there's a pretty good bet for the foreseeable future that we are not going to see major changes in the process to acquire an approved PERM labor certification application, that is, in the acquisition of the benefit. I think that we're going to see some major changes and new emphases in the compliance arena, and that's exactly what Lon is going to address in her segment. Another issue, which is quite concerning, is whether we'll see any revisions affecting the international student population, both in the admission of foreign students to the United States, but more importantly, in their ability to acquire work authorization following graduation. There are two programs under which F1 students can get employment authorization in order to gain real-world experience in the area of their academic studies. One is a program that all students qualify for called optional practical training, and that's a 12-month period of employment authorization. But then for STEM students, that is, students, or more particularly graduates in STEM disciplines, defined as science, technology, engineering, and math, there is a possibility to gain 24 months of additional employment authorization, thereby bringing their period of employment authorization up to 36 months. Here's the importance of OPT and STEM OPT. First of all, it is a major impetus for international students to come to the United States. Secondly, this window of employment eligibility provides a very needed bridge from the F1 student world into more permanent or long-term immigration in the United States, either for an F1 student to attain permanent resident status or H-1B status. And number three, this is really a very needed initiative in order to get thought leaders and emerging leaders and critically needed professionals, particularly in the STEM disciplines, to commit to coming to the United States. And all of the statistical data indicates that the OPT and STEM OPT program are absolutely essential in order to preserve U.S. competitiveness, particularly in the technical sciences. OPT and STEM OPT is something under which the administration, the incoming administration, could exert enormous influence in terms of revising or truncating to varying extents, because it's a function of regulatory enactment. Therefore, we really don't know yet to what degree, if any, the F1 student program, and in particular its corollaries in the OPT and STEM OPT fields, will come under analysis by the incoming administration. Moving on, one of the quite controversial elements for permanent residents has been the EB5 Investor program, probably stemming from a basic disquietude in the United States of linking immigration benefits to investment capital. Quite regrettably, over the years, the EB5 program has come under significant pressure, and its renewal has recurrently been delayed. This is one area where I think that we can expect some concerted support and concerted initiatives from the incoming administration, not only to preserve the program, but very possibly to expand it, particularly by liberalizing the job creation provisions under the EB5 program. In conclusion, what I've gone over, that is H-1B, permanent residence based on PERM applications, the F1 student program, and the EB5 investor program, are the main issues that, at least thus far, have surfaced as being susceptible to change and revision under the Trump administration. There's a wide range of other employment initiatives which over time may also be undergoing reanalysis under the new administration, but that will be the subject for future sessions. Thank you very much.
Good afternoon. Thank you for joining us today. I'm Lon Huynh, and I'm going to be speaking about worksite enforcement, compliance, and employer rights. Well, we've heard a lot about immigration enforcement during the election, and President-elect Trump has made it very clear that immigration enforcement will be a priority for his administration. But it's not just about the wall that we've heard so often about. It's going to be about immigration enforcement for employers also. I am going to focus on some specific topics that we think will be addressed by the Trump administration within the first year. And it includes a continued focus on I-9 audits, the potential for mandatory EVerify, an increase in worksite rates, and also an increased focus on immigration compliance, specifically investigations of immigration audit files, and an increase in the fraud detection and national security investigations. We recently heard that the Trump administration has backed away from its request for the Mexican government to pay for the wall, and that it will take responsibility for building the wall that it is focusing on as a main enforcement priority. And we expect that perhaps the money that it will get from increased immigration enforcement against employers may be a way for it to pay for the wall. The Trump administration's immigration plan has stated that it will focus on turning off the job and benefits magnet in regards to immigration to the United States. And that statement is directed to the ability of U.S. employers to hire individuals who may not have work authorization. So in regards to I-9 audits, we expect to see a continued focus and perhaps even a further increase on I-9 audits. Since 2009, the Obama administration has conducted 10,000 I-9 audits and issued $100 million in I-9 fines. As previously stated, we believe that the focus on I-9 audits will continue, and employers should be proactive in preparing their I-9s, such as conducting internal I-9 audits and setting clear I-9 procedures in place. We are also going to see some changes regarding the use of I-9s. As of January 22nd, 2017, all employers will be required to use the new I-9 form. And this new I-9 form is what is considered a smart electronic I-9 form, in which employers and employees can complete the I-9 form online. And the I-9 form will direct assistance on its completion through text helpers that are available on the electronic I-9s. So we will expect to see a change in I-9 processes among employers as they try to comply with this new I-9 form and seek assistance in regards to making sure that all employees complete the I-9 form correctly. The Trump administration will also be working under a new government agency. Actually, it's an existing government agency, the Office of Special Counsel on Unfair Immigration-Related Employment Practices. Recently, the Obama administration issued regulations which renamed this agency and also clarified further guidance on how specific acts by employers can constitute discrimination based on immigration status or national origin. So what we find now is that under the incoming administration, employers are going to be caught between a rock and a hard place. They have a new administration where we expect immigration enforcement and an increase on I-9 audits to be the continued focus, but also a agency that has been reorganized to be called the Employee and Immigrant Rights Office, where it will lay out specific guidelines as to what constitutes discrimination. And we have also seen an increase in the activities of this office in regards to investigations against employers on acts constituting discrimination based on national origin or immigration status. So employers are really caught in the middle of this focus of immigration enforcement under this incoming administration. And yet at the same time, we know that President Trump has also expressed his position as a pro-business candidate, and it will be very interesting to see what type of action he will take in order to support businesses, but at the same time carry out his immigration enforcement priorities. Another component of immigration enforcement that we expect to see under the Trump administration is perhaps a change in the existing EVerify program. The EVerify program, as many of you may know now, is a voluntary program unless you are a FAR contractor. So employers are not required to use the EVerify program as part of its I-9 process. There has been discussion among the Trump immigration transition team members about the mandatory requirement of the use of EVerify. Currently, there are 650,000 registered employers under the EVerify program. Laura mentioned a little bit previously about the use of executive action. We have heard discussion or chatter about perhaps the expansion of EVerify through executive action. That was how President Bush in his administration implemented the FAR EVerify program. In addition to expansion in EVerify, we expect to see a continued increase in desk monitoring and EVerify site visits. This is already occurring right now under the Obama administration, but as more employers use EVerify and the continued focus will be on removing individuals who are not authorized to be in the United States continue and gets refocused under the Trump administration, we expect the executive branch to start using EVerify as a tool in which it will enforce removal orders or search for individuals who are not authorized to be in the United States. Employers need to be prepared for worksite raids in addition to what we call immigration compliance audits, investigations. Worksite rates was the practice that that President Bush used during its administration to carry out immigration enforcement. And we expect the Trump administration to bring back worksite rates. And the reason we believe this will happen is because the Trump plan has made it very clear that it will seek out individuals who have crimes, who have been convicted of crimes and who are here unlawfully. And we have seen the use of worksite raids as a tool in finding these individuals and also arresting these individuals. So employers need to be prepared, and they need to make sure that they prepare their management team and their employees of potential worksite raids and audits. Employers need to understand that you have rights. We have received calls from employers asking what should we do if we are contacted by the Immigration Service about an employee who may not be authorized to be in the United States. What rights do we have? And employers do have the right to inform an investigator or an auditor that they would like to contact legal counsel if they're contacted. It's also very useful if the employer can set a audit or investigation response plan and communicate this to their management team and those employees who may be the first point of contact if the Immigration Service or other government officials contact the employer. So as we did in the Bush administration, we encourage employers to set a response plan, internal response plan when it comes to government investigations or rights. Be sure if you are contacted by the government regarding an employee or any type of immigration issues, such as an audit of your labor condition application, public access folders, or your PERM audit files that Bob previously mentioned, that you cooperate in that you acknowledge that they have the right to contact you, to speak with you, but you as an employer and your employees also have the right to contact legal counsel immediately and not engage in conversation without legal counsel present. So the most important thing you need to remember as we start to enter this time of increased immigration enforcement is to make sure that your I-9 audit files are in order and your immigration audit files are in order. The Trump administration has made it very clear that it plans to establish immigration controls to boost wages, to ensure that jobs are offered to American workers first, and that means we expect that it will target employers who are hiring foreign nationals to ensure that these employers are in compliance with their prevailing wage obligations and they have conducted the requirements to test the labor market to protect U.S. workers. Thank you.
Hi, this is Debra Schneider, and I'm here to talk about the employee perspective of what's going on with the new presidency and the Trump administration. The first thing that happened to me right after the election results was my phone was ringing off the hook, coming from employees who were very nervous about their future and what would happen to them, to their families, to their jobs. And I think the best answer I could have for them is nothing as of now. Let's think proactively and think responsibly of how to protect yourself with a change of environment, with a campaign that was aggressively against immigration, but yet what we're seeing with, as Laura had discussed, what the administration can actually impose and what we think will really happen in a professional work environment may be very different. So what will happen when your employees come to you and say, what does this mean for me? Well, the most important thing is to make sure that you maintain your employee status. So that may include having an excellent system to ensure that your employees checking their I-94 record when they come in and out of the country. So we make sure there weren't mistakes or errors made when they cross into the border. Make sure that we have timely filed extensions. Think strategically and plan ahead, not just for the next year, but maybe for the next 3 or 4 years, and looking at how can we help protect your employees. Looking at permanent residence, what you're also going to see is many employees coming to you who are here in non-immigrant status to want to seek how can they provide a more permanent status, such as seeking a green card. This is actually a very good opportunity for you to engage with your employees who are long-term workers to show that they're valued to your company and that you too want to be able to maintain their ability to continue to work for you in the future. It's going to change their lives, their families' lives, and give them more security to stay here in the United States. It's also an opportunity for those who already are permanent residents to start becoming U.S. citizens. A time to naturalize is a time for them to feel the utmost protection in America. They can't be deported. They're going to be able to sponsor other relatives in the United States and continue to be full engaged members of our community. Well, what we do feel could be an area of concern involves travel. What we have seen come out is an increase in this idea of a vetting process. With Rex Tillerson as charge of the Department of State, we do feel that there's someone who's very familiar with cross-border issues, but the directive is very, in my opinion, evident that they're looking to see how can they put a harsher imposition on those requesting entry. And this is going to likely entail those applying for visas from abroad. We've already seen an increase in administrative processing, and what that means is when your employee is applying, for example, for an H-1B visa abroad, they fill out the proper application, they have a prior approval notice from the Immigration Service, and yet when they request their visa, they may be issued a 221G letter and placed in what's called administrative processing, which is a security check clearance hold. What the reason behind it is, you almost never know. It could be a background check, it could be an employer check, it could be an education check, and I believe we're going to see an increase in this happening. What does that mean for you? Well, your employee could be on a 1-week business trip could turn into a month to 3 months outside the country. We saw this happen after 9/11 when there was a whole new vetting process, and the administrators report is they want to see an increase in biometric visa processing at all consulates, including at U.S. border posts and land border posts, which you can imagine is going to cause increased delays at nearly every border entry into the United States and the ability to even get visa appointments abroad. What this also may mean is increased security checks for individuals from certain countries. Now, fortunately, there was a program called NSEERS, which was recently canceled, fortunately, by the Obama administration. But this was put in place after 9/11 with a great deal of fear about individuals from certain countries, particularly those from Muslim countries, which required a registration process. And this is something that the Trump administration has looked at imposing again, maybe not with the same term of NSEERS, but this withdrawal will make this more difficult. But I would not be surprised from individuals from countries with high Muslim populations or a history of terrorism are going to have a much higher vetting process than others. What we also may see is a heightened ground of scrutiny from the Customs and Border Protection. And this is the agency that actually allows people to physically enter the United States. And they have extreme discretion, meaning if your employee has the approved petition, they have their visa, they still have to be allowed entry into the United States. And these officers have full authority to say yes or no, sometimes without good cause. And that often means that your employee is lacking due process, they do not have the right to call counsel. You may not even be aware that they haven't been let into the United States until they've already been returned home. And what we often hear is people are placed into what we call secondary inspection. And this is where they may be waiting and questioned about who they work for, what do they do, what's their background, what countries have they visited. And when this happens, your employee is going to be very scared and very worried and may not want to travel again. So what we want to make sure you do is be aware of when your individuals are traveling. Have them have contact information of an attorney plus the HR at the company. Have them have a personal contact so people are aware if they didn't enter when they were supposed to, people are contacted so we can review that. And we can help them be comfortable in answering questions so they're more familiar with the process and aren't confused or nervous if they are put into this additional screening. The one category of immigrants and foreign nationals who are going to be at the highest risk are those with criminal records. I do believe that they are going to be an instant and an easy target. Right now, criminals, aliens are not necessarily allowed in the United States either when they have been convicted of certain crimes. But I do believe this is going to be a much more expansive review, and the amount of discretion used to potentially parole people in may end. And I think we're going to see a much higher level of scrutiny. And this involves not only crimes in the U.S., but crimes anywhere in the world. I think if they increase biometrics, increase fingerprinting, and additional communication between countries, much more of this information is going to become evident and going to be much harder. So it is important to, before allowing employees to travel, to screen for criminal records because they're at the highest risk. So what do we do from a positive standpoint? And be aware of your rights. As Lon has discussed, employers have rights, and so do your employees. We still have a fantastic Constitution and rights of due process, and it's our job to uphold those and make sure we stand up for. If you have a proper visa, if you have family, you own a home, you have the right to be here, to feel comfortable to request those rights, not waive them. And continue to be a positive force for immigration. Your workforce is diverse and you've invested in them. And it's important to stand up and not let them feel vulnerable to what they may hear on the news or hear coming out of certain individuals in Congress or in power, and show that you support them. You support them as part of your team and part of your community. So be diligent, continue to support your workforce, and know that we all believe that everyone has the right to live, to work here, and foreign nationals greatly contribute to our society. And we, as your lawyers, are here to advocate and fight for the rights on your behalf. Thank you.